Good morning, viewers. Welcome to Consumer Short Hand Classes. ఇవి రెండు పార్ట్లుగా ఈ వీడియోలో కలిపి చెప్తాను. ఒకటి అప్లికేషన్ అండర్ సెక్షన్ 145, సెకండ్ పార్ట్ వేరే సబ్జెక్టు అయినా కూడా దీంట్లోనే కలిపి చెప్తాను. ఓకేనా? రైట్. గెట్ రెడీ ఫర్ డిక్టేషన్. 5 seconds. Start. In the court of executive magistrate at Tirupati, Chittoor district, between C.H. Ramarao, petitioner, versus C.H. N. Rao, opposite parties. Application under section 145 CRPC. The petitioner above named begs to submit 1. The petitioner is in actual and lawful possession of the immovable property bearing number 3, ward number 3, under Tirupati Rural Police Station within the jurisdiction of this honorable court. 2. That the structure is divided in 2 parts. One part is used by the petitioner for the purpose of running a shop in the name and style of Rama Brothers. The remaining portion is used by the petitioner for the purposes of his residence. In particular, details of the property are described in the schedule hereunder. 3. That the opposite parties setting up a colorable claim to the said properties in their right forcibly and wrongfully dispossessed the petitioner on 3/12/2024 while the petitioner was in actual possession of the scheduled property and are preventing the petitioner and his man from entering into the said premises. 4. The petitioner apprehends that the dispute is likely to cause a breach of peace concerning the scheduled property situated within the jurisdiction of this court. In the circumstances, the petitioner prays that the honorable court be pleased to make an inquiry as to the actual and factual possession of the said premises, allow the petitioner to adduce evidence in support of his claim, and on proof thereof make an appropriate order to restore possession to the petitioner and restrain the opposite party from entering into the scheduled property and disturb such possession. Further, the petitioner prays that pending such inquiry, your honor may be pleased to attach the disputed property to protect the interest of the party rightful entitlement to the possession thereof. Tirupati 4/12/2024. Be pleased to consider petitioner. Advocate for the petitioner. Now the second part. The allegation by one of the disputing parties is that he is in joint possession over the land in question along with other party. The matter has to be taken out from the ambit of section 145. Pendency of proceedings under section 107 between the parties is not a bar to initiate a proceeding under section 145. There is no legal bar for initiation of proceedings under section 145 against the master or the servant. A magistrate is not bound to give the applicant under section 145 an opportunity to support his allegation. An application under section 145 is only giving information and doesn't amount to instituting a case. A magistrate refusing to initiate proceedings need not give reason for it. The existence of an order of injunction of a civil court creates a bar against passing of any order under section 145, 146 CRPC subsequently. An inquiry under section 145 is limited to the question as to who was in actual possession on the date of the preliminary order, irrespective of the rights of the parties. The magistrate cannot, under section 362, review the final order made by him or his predecessor. The remedy is to go to a civil court or apply for revision in a proper court. Revision lies both to the Sessions Court as well as the High Court. That's all.